Impeachment is part of cross-examination, but in some ways it is fundamentally different. You'll remember that in cross, we are introducing a new fact, highlighting or weakening or strengthening a fact that's already been admitted, or we're attacking the credibility of the witness. It's in attacking the credibility of the witness that we really begin to use our specific impeachment skills. So when do you impeach? When do you go after credibility of a witness during a cross-examination? Well, there are some specific questions that you can ask yourself that will help you in making that decision. First of all, has the witness said something that helped your case? It may be that you've gotten sufficient supportive information from the witness that you don't want to call their credibility into question. You always need to ask that before you go down the path of impeachment. And then you've got to ask, if I'm going to impeach, is the method of impeachment that is available to me going to completely destroy the credibility, or will it be more like a surgical strike that will only take out part of the credibility of the witness? So, for example, bias and motive to lie is the type of impeachment that can be focused on a party, whereas something as simple as conviction for a fraudulent crime, a crime of dishonesty, that sort of calls into question the entire character of the witness. And this is a decision that you have to make in the moment when you get up to cross-examine. And then I could also ask, by impeaching this witness, will I make myself look more honest in the eyes of the jury? Because doing it for purposes of increasing my credibility as a lawyer, that's a completely effective reason to do it as well. So, if I decide to impeach, do I have the ability to impeach? Because a lot of times we can have the desire but not the capacity to accomplish a goal, and we always need to know that before we go down the path of impeachment, before we engage at that level with the witness. Is the jury going to see it as a trick, or is the jury going to see it as something valid? That's another way of saying, is the impeachment sufficiently important that I should spend the time doing it? And then I want to always have in the back of my mind, as I decide to attack the credibility of the witness, have they presented to date as an intrinsically truthful person, such that the jury is going to have a hard time believing this impeachment when I engage in it. Now, the rules of evidence and case law give us some ways that we can impeach prior bad acts for truthfulness when it's the witness on the stand, prior convictions, prior inconsistent statements, bias, prejudice, or motive to lie, defects in their ability to observe, recall, or relate, impeachments by omission, where they should have said it previously and they've never said it before today, and then, of course, impeachment on non-collateral matters, issues that are germane specifically to the case and that the jury should be allowed to hear. Prior untruthful acts is a character impeachment. We're basically saying because this person has been untruthful in the past, you cannot trust them today. And when I impeach someone for a prior untruthful act, you should always remember that it's a collateral matter in the minds of the judge. What does that mean? It means that if the person that I'm confronting with the prior untruthful act lies, I'm stuck with the answer. I cannot offer extrinsic evidence to prove the fact that they did commit that lie at a previous time. It's normally admitted through cross-examination or through reputation or opinion testimony after the witness has taken the stand. It's an effective means when used properly, and is permitted under the rules of evidence. The second primary way that we can engage in impeachment is when the witness has a prior conviction that qualifies under the rules of evidence as being admissible at trial. Now, different jurisdictions address prior convictions in different ways. In the federal system, if it's a felony crime and it's been less than 10 years since the crime and the punishment for the crime were completed, I can admit the record at trial, and I can ask the witness if they were convicted for a specific type of crime. In many state courts, they'll allow you to admit the conviction, but they won't let you identify the type of crime unless the witness lies about having been convicted about the crime on the stand, and then you're allowed to admit the conviction and the type of crime for impeachment purposes. There are two types: felony convictions, less than 10 years and we're good, and falsehood crimes. They're called crimen falsi, crimes of fraudulent behavior. That doesn't even need to be a felony. And in the first 10 years after completion of punishment, to include, by the way, parole or probation, we can admit the conviction for the fraudulent act, and the judge cannot even stop it under a 403 balancing test. We believe intrinsically as a system that if a witness has been convicted for a criminally fraudulent act, that's something that's highly relevant and probative of their truthfulness. And so the rules allow us to impeach with it where appropriate. Most folks, when they think of impeachment, actually think of impeachment with a prior inconsistent statement under Rule of Evidence 613. Impeachment with a prior inconsistent statement is where the witness has said something today on the stand under oath, and they've previously said something different, either in writing or just orally to someone. The trick with the prior inconsistent statement is that I must have the means to produce it. And it's admitted not substantively for the truth of what's contained in it, but just to show that the witness has changed their story. We do that by committing the witness to what they just said in court, crediting the circumstances of the earlier statement so that it is more believable that they were being truthful then, and then confronting with the inconsistency. Classic example is something as simple as the color of a car in a car accident. I have the witness on the stand, and they've just said on direct examination that the color of the truck was red. Now, the color of the truck that was driven by the plaintiff happens to have been blue. And this is a material fact of the case, and I have to cross-examine. They've never been deposed before, so I don't have substantive testimony, but I do have what they said to the cops at the accident scene. So how would I commit, credit, and confront? Mr. Witness, you just said on direct examination that the color of the truck was red. Yes, I did. Sir, that's not the first time someone's asked you about the color of the truck. No. You were asked about the color of the truck the night of the accident. You'd just seen the accident. The events were fresh in your mind. You'd not yet spoken to an attorney. You had not yet spoken to anyone other than the police officer. I have here a copy of the police report. Would you agree with me that you told the police officer that the truck was blue? Now I've got them, right? Now I can't give the police report to the jury. I can't argue that the truck was blue based upon that impeachment, but I can surely argue that the witness was not being truthful on this important fact. And that's the way you do impeachment by a prior inconsistent statement. The only real devil in the details with impeachment by a prior inconsistent statement is the nature of the earlier statement, because I have to go through an evidentiary analysis to see whether or not I can also lay the foundation to admit that prior inconsistent statement substantively. The last two methods of impeachment I will talk with you today about are bias and motive to lie and impeachment by contradiction. Impeachment by contradiction is where the witness has said something previously and now they've said something different, and it's a non-collateral matter. And when they've done that, I'm allowed to confront them with the change, and I'm also allowed to present that evidence substantively because it's on a non-collateral matter. And that's how it differs from prior inconsistent statement impeachment. Bias, prejudice, and motive to lie is admissible to show that the witness has a predilection for or against one of the parties or another witness in the case. And the argument is that bias or prejudice has influenced their partiality or their impartiality, such that their testimony is no longer capable of being viewed without understanding the bias and the prejudice. Bias and prejudice can be phenomenally effective when used properly. And remember, it's a non-collateral matter, and that means that the evidence of the bias and prejudice is also potentially admissible. Now, we've talked about various means and methods of impeachment. I want you to remember as you practice them and as you work with them that you don't abandon your cross-examination skills of one fact leading questions leading up to the goal, and that you properly defined whether or not you should impeach, and that you understand completely the method for doing so. If you'll do those things, you'll make impeachments that matter, and that's the purpose of it.